Chief Legal Analyst Khalif Rhodes. Khalif, North Carolina, they haven't used the death penalty since 2006. That's the last time somebody was put to death here. What does this process look like, and how likely is it that we see a death penalty?
Not likely at all. Mecklenburg County is extremely low in terms of being a non-heavy death penalty type of county. Each county prosecutor's office will make a determination. Today is them formally announcing that determination. I know the movies and TV shows will have attorneys look like there's not many rules, that go kind of, wild, wild west of any profession, but there are a number of rules stacked on top of rules. And so there's the rules of general practice and procedures in district and superior court. That's where this hearing comes from. It's called a Rule 24 hearing. If you are in a capital case, the prosecutor's office has to announce in open court that they will seek the death penalty or they will not seek the death penalty, because it triggers a number of things. If the individual has an attorney that's appointed by the state's capital defender, then instantly, if the state decides to seek the death penalty, a second attorney will be assigned. Because it's a capital case, it will be a lot of other moving parts and it will trigger a lot more manpower. And so that has to be announced, and the state will typically point to factors, aggravating factors, specifically something egregious that happened outside of the actual homicide itself, but something even worse than that that compounded this. Typically, that's what would elevate it to the capital case. I handle capital cases all day. Every case that's a homicide, that's a first-degree murder, starts there. And then after the Rule 24, it's taken down. And interestingly enough, for bond purposes, the statute still dictates that it's still determined a capital case, even though they've decided not to move forward seeking the death penalty.
Well, and there's no bond in this particular case, because clearly Benjamin Taylor's a flight risk if he was found in Southern California at the Mexico border. Well,
and that's part of the process, but North Carolina's general statute has a couple of things. It says for all cases, bond must be set, must, M-U-S-T, for any case, except for homicide, where it says the judge may set conditions for release. And so in this case, they would do an evaluation like they would in any other case, determining if this person could commit some crime, specifically a new violent crime, and their likelihood to appear. And so you're going to look at their past. If this person has eluded, has fled, has went to another state, was hiding out in the middle of a desert, yeah, it's probably likely that they're not going to come back to court to appear to defend themselves. And so that would be the number one factor that the DA's office would argue. But after this Rule 24, after the defense has got an opportunity to receive discovery, to see what actually the state is alleging has happened, they'll ask for another bond hearing for the judge to readdress conditions for release. And at some point, the judge may say, all right, I'm satisfied that this person will come back, or I'm not. I'm satisfied that they still are maintaining a danger to our community and won't come back to court, and so I will issue no bond. The overwhelming majority of homicide cases in our state do have some condition for release. It just may be extremely high, like $1 or $2 million. But in most cases, when you have a person that's fled, it'll just be no bond, zero bond at all.